Welcome to the new episode of Bharatiya Nyaya Sanhita 2023. Today we continue with studying the definitions as defined in section 2 of the Bharatiya Nyaya Sanhita, in short BNS. Section 212, Government. Government means the central government or a state government. Same definition is given in the Indian Penal Code also, section 17. Government. The word government denotes the central government or the government of a state. As per section 212 of the new BNS, government means government, central government or state government. Sometimes the term government means the central government, and at some other area it may be state government. So while reading a section, while interpreting the meaning of a particular section or a legal provision, we have to keep in mind what is meant by government. Normally what we think, government means the government which is in power. But as far as India is concerned, India is a federal state. Federal state means, as per the law of federalism, there will be two types of governments. One government will be at the center, ruling the entire India, and in particular areas, different states ruling that particular locality or region. Earlier, India was divided on the ground of language, and thereafter there are other conditions also. For example, the Karnataka, now it's divided into Telangana and Andhra. The Andhra Pradesh is divided into Telangana and Andhra now. Both states speak Telugu language, but it is divided into two. Earlier, there was only one state, Andhra Pradesh, which speaks the language Telugu. So this is the differentiation between the central government and state government, and we have to interpret according to the situations. Both these government will be independent in their respective spheres, and in the 7th schedule of the Constitution of India, the powers or jurisdiction of the state government as well as the central government is defined and prescribed. There are three lists. One is union list, second list state list, and the third one will be the concurrent list. So in the union list, certain subjects are provided, for example defense. So the central government or the union government will be dealing with that. In the state list, certain other things are provided in which the state government will have exclusive jurisdiction. As far as concurrent list is concerned, both the central government and state government will have jurisdiction, and if both governments, for example the central government enacted a law and the state government enacted another law, then the central law will prevail, because in the concurrent list both the central government and the state government have got the power or jurisdiction to enact law. But as far as state list and union list are concerned, no government can enact any law regarding the other subjects. For example, in the union list matter, state government cannot enact any law, and in the state list matter, the union government cannot enact, and if such law is enacted, the Supreme Court or the court can declare it to be null and void and not binding, or even the law can be struck down. Earlier, Kerala government enacted a law regarding the Mullaperiyar dam, so Mullaperiyar issue, and finally Supreme Court had to decide on that subject. So government means, in appropriate situation, either it can be central government or the state government, and we have to keep in mind this difference. Just don't understand the government. Government can either be central government or state government. Section 213 of Bharatiya Nyaya Sanhita. Harbour. Harbour includes supplying a person with shelter, food, drink, money, clothes, arms, ammunition, or means of conveyance, or the assisting of a person by any means, whether of the same kind as those enumerated in this clause or not, to evade apprehension. The corresponding definition is given in the Indian Penal Code, section 52A. 52A of the Indian Penal Code, Harbour. Harbour means except in section 157 and in section 130 in the case in which the harbour is given by the wife or husband of the person harboured. The word harbour includes supplying a person with shelter, food, drink, money, clothes, arms, ammunition or means or conveyance, or the assisting a person by any means, whether of the same kind as those enumerated in this section or not, to evade apprehension. So section 213 says about harbouring. Normally, when we hear the term or word harbour, means some harbour or a port or things like that. It is not like that. In law, in the Bharatiya Nyaya Sanhita or Indian Penal Code, harbouring means giving shelter or assistance to a person to evade apprehension. Which means, assume for a moment a person has committed an offence. And after commission of the offence, this person, this accused, wanted to escape apprehension, means arrest. So in order to evading arrest, he may want to hide himself in some other place. So that is just avoiding apprehension by a person. Normally it is said absconding. After commission of the offence, the accused knows he has committed an offence and he just absconds. Means police may not be able to arrest him. He hides himself. But harbouring is something else. The person who commits the offence of harbouring has not committed any offence, but he gives assistance to the person who already committed the offence. Suppose if a person who committed the offence just escapes from the place of occurrence and then he hides in a particular place. Assume for a moment that is the house of his friend or flat. So a person committing offence in Cochin and he goes to Mumbai and stays along with his friend in his flat in Mumbai. Then the friend in Mumbai commits the offence of harbouring, knowing that this person has already committed the offence. Assume for a moment the friend does not know that this person has committed the offence, then that friend can take a contention that I was not aware of. That is there. But knowingly, that is the important aspect. Knowingly, a person gives assistance. This assistance can be of any kind. Just providing shelter, even giving food or clothing or any other assistance. Whatever form of assistance for an accused to hide himself, to evade apprehension, to evade arrest, that amounts to harbouring. So this the general public and the law students must be aware of. Knowingly, you are not supposed to give any sort of assistance to a person who committed the offence. Knowingly. Then you may just say that suppose if a doctor treats a patient knowing that he committed an offence. For example, while assaulting a person, while fighting with a person, while attacking a person, the person who attacks also suffer injury. The assailant also suffer injury. The culprit also suffer injury. And if the doctor treats that person, whether it amounts to offence of harbouring, no. There, the doctor is discharging his duty as a doctor. The duty of a doctor is to treat a patient. So this person may be suffering serious injury and the doctor is treating. That is not harbouring. But if the doctor allows that person to hide himself in the hospital without records, then it is harbouring. So what the doctor has to do? Doctor can treat the patient but simultaneously inform the police. Likewise, suppose if this person goes to a restaurant and having food, whether the person who runs the restaurant commits any offense or the waiter commits any offense, no. Giving food is not a problem, but he may not be aware of that. But giving food continuously so as to avoid apprehension, then it amounts to offense. So by after giving food, immediately informing the police, that is not an offense. But continuously giving food, continuously providing shelter, and knowingly this is not informed, this matter is not informed to the police, then the offense of harboring is happening or being committed. One interesting aspect, as if for a moment the husband committed an offense and he came back home, whether what happens to the wife, whether the wife also can be held guilty of the offense of harboring? No. Wife and husband are given exemptions. Merely because the wife did not inform the police that the husband committed an offense, wife cannot be prosecuted. Same is the case of the husband. Assume for a moment the wife committed an offense. Then the husband is not informing the police. Then husband also exempted. So this exemption is given only to the wife and husband and to none else. So if anyone, the general public, be aware of the commission of the offense and the hideout of an accused, then immediately inform the near police station or police and let him be apprehended. Apprehended means let him be arrested and prosecuted. Let the law take its own course. Purposefully, he should not assist that person. Just giving food, just giving medicine, just giving treatment is not enough. Suppose if a person travels in a train, after commission of the offense from Ernakulam to Mumbai, can the TT be prosecuted? No. He is not aware of itself. But knowingly giving a vehicle to escape, to give a room to hide himself, continuously giving food or clothing, so that this person will not be arrested by police, then the offense of harboring is committed. So this you may keep in mind. Section 214 of the Bharatiya Nyaya Sanhita. Injury. Injury means any harm, whether illegally caused to any person in body, mind, reputation or property. The corresponding provision in the Indian Penal Code is Section 44. Section 44 of the Indian Penal Code, injury. The word injury denotes any harm, whether illegally caused to any person in body, mind, reputation or property. As per Section 214, means Section 214, subclause 14 of the Bharatiya Nyaya Sanhita, injury is of different kind. Normally what we understand, injury means just bodily injury. But in law, it need not be so. Bodily injury is also there. Any injury, either in body or mind or reputation or even the property, is also an injury as per law. So the word injury is substituted by the term harm. Any harm to body, mind, reputation or property is a legal injury. And this injury must be caused illegally against the law, either the civil law or criminal law, against the legal provisions, against the legal rights of a person. If any injury is caused, either to the body, mind, reputation, property, the term injury, the offense of injury or the definition of injury be completed. So this injury can be in civil respect also. For example, if I have a property, a car, and my car is stolen by someone, then it's an injury because I suffer, I lose my property, my car, then it's a legal injury. somebody says some slanderous words or rebellious words or defamatory words against me, I suffer injury to my reputation. That is also an injury. So, while using even words, slander means the spoken words, and libel or label means written or in an express form. In either way, it causes injury. Then mind, using some words against a person and that causes some injury to his mind, that is also a injury. Saying that you are a cheater or you are doing some other illegal occupation, smuggler, or you are doing some other job, illegal job. So all these creates injury or harm to the mind. That is also a legal injury. And of course we know injury to the body is also an injury. This type of harm be defined as injury in law. So whenever we read the statute book, especially in the penal law, the term injury is used, then it can either be in the body or in the mind. Can be even in the property or of reputation. So this definition we should keep in mind. And there is a term wrongful gain and wrongful loss. So that is something connected with the property. We have certain legal rights and certain legal liabilities. It can be even connected with civil law also. So my legal right is affected, it causes me injury. If I affect the legal right of another person, then also it causes injury. So injury of multiple claim. But act causing slight harm, certain things, just touching a person, just saying some words for fun, just joking, or unintentional hitting, all these are not legal injuries, which means act causing slight harm. And this injury must be purposeful also. While traveling in a train or in a bus or being in a room or in a road, accidentally two persons hit each other, then it is not an offense. Because suppose a person is going to catch a train or even a bus. Other one may be going to catch another bus or train. So accident they may collude or hit against each other. So this type of injury, even if severe injury happens, body injury happens, it is not intentional. But purposefully using a knife or even a pistol and hitting a person or shooting a person, using weapon or even stone, or even by using fist, causing injury to a person, that amounts to injury. While dealing with offenses, dealing with the human body, then this injury is very much important. Injury can be caused and that can be resulted in death of a person. Then it will become the offense of murder. Other injuries can be divided into hurt, that can be simple or grievous, then several other injuries also. So the students of law must keep in mind, the general people or general public must keep in mind, injury means harm. Any type of harm, either in body, mind, reputation, property, we consider as injury in law. Kindly inform your doubts and your suggestions, and that will be clarified in the next episode. See you then. Thanks.